going to call the meeting to order. I forgot my agenda right in front of me. I should have. Sorry about that. First, we have on our agenda, we'll have our roll call. Dylan, if you would.
Yep. Bernal, Elliot Pahinui, Melendrez.
Here.
Oshiro. Here. Smith.
Here.
Beret.
Here.
Yoninaka. Here. We have 5 present, Chair.
So for our missing commissioner, our committee chairs, Kathleen has another meeting, and she might be able to join later, but most likely not. And Mahea also has a meeting that she presides over, so she has to make that just to put on the record. So first on our agenda are public concerns. Do we have any public concerns? Oh, Tom, go ahead, please, sir.
Aloha. Good evening, everybody. It's been a busy Monday for everybody. Just one thing I wanted to bring to your attention. May have said it at the last time, but a lot's been going on. And that is one of the things for us to pay attention to is the start of the Honolulu City Charter Commission activities. I don't know the schedule myself. I gotta check into that, but I understand that the preliminary meetings are taking place now. One person brought that to my attention about a week and a half ago, right at the wrap up of conference time there at the Capitol, and brought up an interesting idea that I'll share to summarize real quick, and that is interest by several parties in proposing a charter amendment that would be directed, if you will, to the city clerk, but in essence, it would be to establish that the neighborhood board elections should be conducted by the city in conjunction with the regular elections. So obviously, there's a lot of things to talk about with something like that. But it was an interesting kind of heads up that there may be such a proposal coming to the City Charter Commission as it begins to pull together its activities. Okay. Thank you, Chair.
Thank you. I will tell you that if you look at the city charter regarding the neighborhood boards, it's only about a page and a half, and there's not really much substantive aspects to it regarding the composition, except for the composition of the commission itself. But yeah, I would encourage everyone to take a look. But I would hope, and I had that conversation with someone, that I would hope that a lot of the proposals that they have for the charter would actually go through the plan instead. But that's just my opinion. Anyway, I don't know if anybody wanted to comment on that. Okay, are there any other public comments?
Kevin Lai.
Kevin Lai, please.
Chair, thank you. This is decidedly not about anything else that's on the agenda for tonight, but it is neighborhood commission related, and I'm trying to document this as possible in different venues. Preceding this, I'd like to say I appreciate some of the correspondence I've had with some of the members of this committee and other commissioners, but still, I'm here to ask, where's the form specified in Neighborhood Plan 217-403B that addresses a specific form related to challenges to elections? I have requested this form over a week ago and received no confirmation of such or receipt of such from the Neighborhood Commission office. I hope that this type of oversight can be remedied in the future through any change that we might make in the Neighborhood Plan and other sections. But it is concerning that this is a time-sensitive form that's been requested and has not been delivered. It makes me wonder if the form even exists or if it's in the matter of process of being generated and must be approved by the commissioners themselves, but any type of information would be great. Just want to get that documented on the record for the minutes for next month. Thank you.
Thank you, and that is a commission matter, really. But thank you. Do we have any further public comments? Greg Mistakian, go ahead, Greg.
Thank you. Aloha, everyone. There we go. Aloha, everyone. Let me just pull up the thing I wanted to comment on. So on Saturday, I did provide a written testimony overall for the meeting this evening. I'm not going to go into that except to highlight just beginning what I mentioned in it. And I was looking for the proposed written amendments, the proposed changes and some sections, and I did see something posted, I think it was last night. So I was looking on Saturday when I was actually doing my written testimony. And I didn't see some of the specific sections that are mentioned in that agenda item at the beginning. So I'm just wondering if I'm missing something or if they're posted somewhere else.
They were actually, so the material was posted last month and it was in the April folder. There was an update to that, but that incorporated all the comments of the committee and the decisions that we made at our public meeting last month. So it didn't incorporate, it wasn't anything new that was generated, it was just, it incorporated comments from the last meeting. And like I said, it unfortunately was in the April folder, but it was there, so.
Okay, because I also looked in the April folder, at least the one that the public has access to, and let me be specific to it. So it's under new business, it's consider written proposal covering the complaint procedures sections, and then it's proposed 3-2-101, 3-2-105, and then it's got plan 2-18-101 and 2-18-105. So the first two, for sure I didn't see, and I can't recall now on the ones that start with a 2. I know there was some that started with a 2, but those first two, 3-2-101 and 3-2-105, I didn't see any reference to, unless I missed it, to either of those in April or in May, what was posted last night. Am I missing something, or?
Yeah, it may not be very clear, but under our whole package, we renumbered all the provisions. So under the proposed plan, they're 3-2 or 3-2 whatever. Under the current plan is 2-18. Yeah, and I know that may be a little confusing to most people, and that should have been a little maybe more explained a little bit better. But yeah, they're actually the same sort of thing.
Okay, so I get it. So the two, well, maybe I do or don't get it. So you're saying 3-2-101 is going to supersede, would it be 2-2-101, or is this a brand new numbering system? I don't know.
Okay, just to be clear, so when we started the revision process, one of the first decisions we made was to renumber all the provisions. And that is basically, the numbers start a little wonky in the current plan, and there's some dispute of whether that's required or not, and it may be, but our decision was to renumber everything to make it flow a little bit better and move sections around so it flows for the public a little bit better. And that's where those numbers come from. Under this proposal, we're taking the complaint section separately. So we have to retain the current numbering system, or else it wouldn't make any sense. So when we go back and we review or revise the whole package, the whole plan, then the numbers will be updated. And essentially, we probably, I assume, won't touch this unless there's something we really need to fix here and there. So the numbers will be changed at that point, assuming it passes.
Okay, I get it. I think I understand. I just didn't see the numbers anywhere referenced. So if you're going to go from one to another or change, usually you would highlight that this is the proposed change or the section, because that's the way I'm familiar with working on amendment documents. And I guess I have an extensive background in defense electronics, so we used a lot of manuals.
Let me say that we've actually discussed this extensively through our process. And that's, we're not at the stage that this is going out to the public. This is all, mostly internal. The public is certainly welcome to participate, but these numbers are not set in stone, or well, at least the new ones, the 3-2. So if I can understand where people who are just coming on might be a little confused, but it's been extensively discussed. And I've tried to make references back to the original numbers, so hopefully people aren't confused. But
well, I apologize because I didn't get it either, and I guess I haven't been to all of these meetings. I've only attended a few of the neighborhood plan committee meetings, so yeah, I didn't get it either. So I'm one of the board members. But that's fine. Okay, I'll let you guys move on with the meeting.
Thank you. I would very quickly, just respond to your testimony. The bulk of what you sent, other than that particular, the reference material that you talked about, really it's a commission issue. That needs to go to Commission Chairman Ashiro and the rest of the commission. It's not really the role of the committee. And you did say something about our role, and I just want to clarify for everybody online members of the public, our role is just to evaluate and come up with suggestions to revise the plan. And that is, we're just trying to improve it to fulfill our purpose. And the purpose stated in the charter is to increase and assure effective citizen participation in the decisions of government. And that's what we're trying to do, is to improve the plan. So anyway, just with that said, the bulk of it has to go to the commission. So moving on, do we have any further public concerns?
Do you have Michelle Manson?
No.
Because she's trying to get in. She just sent me a text.
Okay. I
Okay.
don't know if anything updates with that.
Okay,
So-
so know that you don't see her in the.
Yeah, she's not here.
Okay, so are there any further public concerns?
No.
Okay, hearing none, we're gonna move on to the approval of committee minutes. We have the minutes of our April 1st meeting. Does anybody have any amendments or corrections they wish to offer? Hearing none, they will be adopted as distributed. Thank you. So we can move on to our new business, which essentially is the focus of the plan. For everybody who doesn't have one, there are some revisions in our public folder. Everyone here, I think, has a copy, hopefully. Dylan, where's yours?
Do you want a copy?
Sure, if you have.
Here, do you have?
I have extra.
Okay, so we're gonna start from where we left off, not where we left off, I'm sorry. We did complete the whole process. It's actually to review a lot of the outstanding decisions that we made. And the first one was, just starting with the first section, 2-18-101, there was some question about the board committee members. And we discussed that there was some talk of dropping that. We could, or else if we go over to the sanctions section, which is 2-18-104B, where it's the particulars, we could add suspension of a board committee member or removal of a board committee member. So we have kind of two decisions. We could include that language, or we could just drop board committee member altogether and make it the responsibility of either the chair of the board or the committee member, or the committee chair, if that committee chair is a board member, which under the rules, under the plan, I don't believe they actually have to be a board member, but we can find out.
They do.
Pardon me, they did? Okay.
That was one later change where the chair has to be a board member. All the other committee members need
Okay.
not.
So, yeah, so our choice is, do we require the board member chair to be the respondent, or can an actual committee member who is not a board member be a respondent? Do I hear any thoughts on the part of the committee? Not all at one time.
Yeah. So if I understand, you're saying if the respondent, I mean the person that is being completed audience, can be a board member, or but can also be a member of the public?
Well, what I'm saying is, so for members of committees who are not board members, can they be the subject of a complaint?
Right.
So that's the question. So it was actually
I don't
included,
think so.
well, it was included in it's included
Yeah,
in the
I
current plan,
understand that.
but there's nothing under the sanctions to address that. So it's sort of like, you either have to add the sanctions, or you have to drop that part of it. And it's just a matter of what is the preference of the committee.
I don't know if it's a preference so much as
You don't think that we can, well, I mean, all our, the only sanction.
walk away.
Well-
from the public.
Oh, yeah, they can walk away, but they just can't
Yes.
continue to be.
Every
a member
board
of the
member
committee.
has an oath of office, and the member of the public on the committee doesn't have a swearing in at all, so.
Okay.
That's a good
Did you want to drop, is it should we drop that and just drop it from 101 and?
Chair, question. So what happens when you have an individual that shows up for meetings and that individual from the public is actually the impediment of the chair trying to get through the meeting because there are continuous, remarks that aren't related to the agenda or whatever, but it turns out that he's just there, that individual is there to disrupt the meeting or attack other board members. How
Well,
do you prevent that guy from coming back again?
well, the chair or the committee or board can remove anyone from the meeting. It is
Yes,
your meeting,
Disruptive.
Yes,
Yeah.
but you gotta fix the problem, okay? He's gonna come back the next meeting.
so- And you.
How do you sanction him if he says you can no longer show these meetings?
I don't think you can do
Yeah, I
that.
don't think you
You
can
just gotta
sanction
remove
them.
them every time. I mean. you know, It's yeah. Sorry, Chair.
Oh, no, no worries. So,
That's why I need a master at arms.
so I hear the decision of the committee is to drop in 101 or a board committee member. So we'll just strike that and then strike the proposed provisions regarding the board member, the committee member in 104B.
Yeah, does that mean that we take out the board committee, no, committee member that's not a board,
Yes.
the board, the neighborhood board can remove that person, the chair can remove that person at will, basically.
Yep.
Because they're appointed by the chair, I would imagine, so you don't need the complaint process to remove that person. So if they're disruptive, for example, and you want to remove them, you just tell them, they're off the committee.
That's right, just the opposite of bringing him on.
Okay.
Because the board has to approve
Anybody.
any public people coming on to a committee.
Okay, go ahead, Dylan.
Kevin Lai had his hand
Kevin.
raised.
Go ahead.
Chair, thank you. I had a question about a different section about what thought we were speaking, so I withdrew.
Okay, thank you.
So, but we're talking about a board committee member,
Not a board member,
not a
but,
board.
yeah.
But you can still have complaints against a committee member, it's not a board.
Right, so, but it would be against a board member who just happened, it may be because of circumstances on the committee, but it's still a complaint against a board member. Okay,
Yeah,
we were all clear?
yeah.
So it's to remove that part of 218,
Board
101.
committee.
Yeah, so, and then, under this proposal, it would be to remove 104B, 5 and 6, where it says the suspension and removal, but that's on page 5.
Okay.
So those would be removed.
And would we also, under the sanctions, would we remove, where it says court member, a board committee member? Remove that too, or leave that?
5 and 6, where?
No, it's on
Where are you looking at?
218-104 sanctions, under A. It lists the,
Oh, yeah, I'm sorry, I missed that. Yes,
okay,
so essentially in the blue,
In
the
the
one in the blue, yeah, would be removed.
Yeah.
Thank you.
and then the other groups.
Okay, yes.
And the reason that came up was that's actually not included in the original sanctions section.
Okay, so moving on to C, just C, section C, kind of 1 through 5. On number 3 and 5, instead of saying to a hearing, because not all complaints are going to necessarily invoke a hearing, it would go for review to the commission. So that, we talked about it, and that would just be a change to make sure that we're not automatically invoking a hearing. That make sense? Any comments?
And where is this now?
This is section 101C on page 1. So where it has C3 and C5, and 5, it just says a hearing disposition, but just scratching that, and in both those situations, just say review, so that the commission can establish, can say we want a hearing, but it doesn't make it automatic, which would be kind of problematic if we said every single one was.
Right, for review, okay.
Right.
Right,
Okay,
okay.
I have
so any comments?
Kevin Lai.
Kevin, go ahead, please.
Chair, thank you. A few questions. The document that I'm reviewing, which was file compliant something, has two sections, 218-101. Can you confirm which one the committee is discussing now?
The one in blue we are ignoring for the moment. I'm actually going to get back to that later on. And that was just added, that was not updated because that was just kind of an addition. And I'll talk about why. So ignore that 101 at the very top.
Okay, if that's the case, I do hope we can discuss that.
Okay, we will.
As far as I'm looking at the 218-101 sub 5,
Yes.
the deadline, is that going to, the question would be, yes, how do we ensure that, you know, these timelines are going to be followed? And the question I had here was if a inquiry is posted about an issue that could become a complaint, language should be inserted here so that that deadline is told while the related inquiry has been filed with the commission through any of the permitted sections, which now are numbers 211-103, 104, 108, and 211-401, so that the opportunity to garner information about what might become a complaint, that right, if you will, to do so is preserved. Otherwise, participants will be, I guess, need to choose to go ahead and file a complaint without a full array of knowledge, or they can wait to get an array of knowledge from the commission, but they might then miss the window for filing an actual complaint if it turns out that it was a complaint-worthy process. So I'm trying to protect the ability to file a complaint, yet also permit the commission to provide information to the potential complainant. That language is in the document that I submitted before the meeting today.
I only had a chance to briefly review that. That's, I suppose what we could do is say, if you file a, I forgot the language of the current plan, a request, I guess it's a request for a declaratory ruling by the commission, that the deadlines will not be told until you get a response from the declaratory ruling. That's something the committee could decide. I mean, we could add. That way, people could choose that avenue without giving up their rights to file a complaint. Does that sound agreeable to everybody? So I could put some language. I mean, that's a good point. I think that's a very solid point. So what'll happen is, yeah, they could file for a declaratory ruling or whatever we call it, and it won't, as long as they do that within, and they'll probably have language, as long as they do that within the 10-day time period, then it won't count against the ability to file a complaint. That would only happen upon issuance of, then I guess the issuance of the declaratory ruling. Go ahead, Dylan.
I guess at that point, what would be the point of hearings?
Well, we wouldn't have a hearing. I would just be a review by the committee to.
I mean, if someone filed an inquiry and said, I want to know if this is a complaint or not, and then the declaratory ruling is, yes, this is a valid complaint, well then, so you're acknowledging, yes, the person is basically guilty because it is a valid complaint.
Well, I wouldn't say it that way.
I mean, that's what it
I
is.
mean, not really.
No. Chair.
Okay, go ahead, Kevin.
Thank you, Chair. I mean, this is an example of how the inquiry is posed not as a specific accusation or whatnot, but it's an example of an event that happened. I guess it's difficult to explain, but there are several examples. For instance, when I would make an inquiry of OIP, I would say, assume this happened. Does this then violate Sunshine Law? And the response that comes back from the attorney of the day from OIP is based on the scenario provided. It doesn't include specifics, but it says if this was the case, then it is likely that Sunshine Law was violated. That would then guide a potential complainant to know whether or not it'd be worthwhile to pursue. And one thing I just wanted to note is that the document that I submitted to you did reverse the language on told and shall not be told. But if there's a suspension of time, then that means the time should be told while the related inquiry is under consideration. Thank you.
Okay, well, why don't we consider this? Because Yeah, I would like to go look at your proposal, but I think we have a sense of what we want to do, but it's just the details. The devil's in the details, as they always say. So unless, I think we're going to talk about the declaratory ruling, I think, at the end, but if there's nothing further, we will just take it under advisement.
Chair?
Okay. Oh, Greg Masakian. Go ahead, Greg.
Thank you. I just wanted to add a comment. So, yeah, it's clear that there's going to be issues. This will be problematic if it's incorporated the way you intend it to be, because it's going to raise concerns with your initial declaration of what or determination of what you believe. With OIP, you know, it's always kind of more of an informal. Sometimes we get a something formal in writing, but it's still semi-formal. So until we file something officially and we get it, you know, maybe a year later, whatever, you get a formal written opinion. But my suggestion that I made previously, if you want to eliminate a lot of these complaints, and when I say eliminate them, let me say resolve them amicably, and you want to get to a point where the NCO is actually doing the job of helping the elected representatives that are volunteers for these boards. My suggestion previously was to, if someone has a concern or complaint, that they can call in, and they can do this on a form. You could call it a semi-formal or even a formal mediation process where, you know, and even if it's in front of the commissioners, that's fine, and with the executive secretary, and just hash it out. So if there's a chair that's concerned about a member, or a member that's concerned about a chair, or a member against another member, you all get in the same room, you sit at a table, you get on a conference call, you sit at a meeting like this, you discuss, and you see if there's a little bit of merit to the complaint. Hopefully, you know, if it's a valid complaint, you'll see there's merit to it. And maybe it can be resolved at that discussion, and it won't even go to a formal complaint. To me, that's where you should be looking. You should try to adjudicate this early, help the elected representatives that are having difficulty with certain members, which I'm having at my board, and move on. And then you probably won't have very many hearings, if any at all. I have a feeling you could actually adjudicate most of the complaint process through just discussion, like we're having right now. So I'll leave that there, and I think that could be part of the process, just like the judicial process has mediation as not just a suggestion, sometimes a requirement. Thank you.
Okay, thank you. We are actually going to talk about, we're going to get to something like that. So I guess the upshot is that we will take the part about filing this declaratory judgment, see how it impacts the timetable and go from there. So, okay. So moving on.
Excuse me, Chair.
Yes, sir.
If I could just raise one question, just for background, if you will, and that is to consider, without further discussion on my part at the moment, but to consider the distinction between request for a formal opinion compared to a declaratory ruling. Because I think in the ways in which some of this is dealt with in other agencies, and I took a look and I brought something that you can take a look at later, just from the Ethics Commission as an example. OIP is similar in the sense of you can request under certain circumstances an opinion if initial advice is not quite enough for you or whatever. But just that language, having written some of this in years past, of a declaratory ruling also raises the formality of the request and your obligation as a commission in order to respond to that. And I think there are lower levels to try to provide that advice or opinion that is still short of a declaratory ruling, which also requires quite a bit of work, both of the commission and commission staff to deal with that. So just trying to draw a distinction there between, if you will, a formal opinion, which does not quite raise itself necessarily to a declaratory ruling by the commission, yet still offers guidance. Okay, thanks.
I think the big difference is that, like, an organization like OIP, and this isn't necessarily for you, Tom, but it's just, I guess my train of thought is they don't issue the opinions, but then they also don't have like adjudicatory matters, and they don't hear complaints and stuff. So they'll give an opinion, and then you can take that opinion and do what you want with it, but they're not also hearing the complaints themselves. And so I think that's why it's like if you issue a, whatever you want to call it, a declaratory hearing or whatever Tom used as a phrase, it's like, well, then you're making that opinion right there when the commission would be the ones who also have the hearing.
Okay,
It gets difficult.
fun stuff. Okay, so we can move on, I suppose. Let's see. Okay, sorry. Were there any other comments? Oh yeah, we can go all the way down to item K of 101, and that is mainly the mailing requirements or the notice requirements. And we didn't update this, but we don't believe that we can get out of the certified mail requirement. So I think we gotta change it to put back certified mail. It's gonna be cut down because a lot of the complaints
Agree.
won't have to get to this stage. But yeah, I don't think saying first class mail, email, and email preferred will probably suffice under Hawaii law. I don't think.
Yeah, but no updates so far, so I mean, for now.
That's true.
Okay, thank you, Steve. Yeah, so I think we kind of came to that conclusion last time, but we sort of let it linger for anyone to offer any insights, and since I haven't heard any.
We'll let you know if we.
Okay, hopefully soon, but okay. Okay, so jumping down to item L. There was a question before about when, I think this was what you asked, Dylan, about what time do we require, if something is required to be filed on a certain day, what is the time requirement? And 4:30 comes from section 2-17-202, which is the voter eligibility and registration, and that's the language that that's the time frame that they use, is 4:30 p.m. So I just inserted here. Is everybody happy with that? I mean, it's this is page 3. It's item L.
About midway.
Okay. I have L as, oh, okay, I see.
So the filing deadline shall be fulfilled by being received by the commission office by 4:30 p.m. on the day required. I mean, it puts a time certain, because before we have all these days, and that applies to the whole chapter. So, you know, as you can see, the language that's used in this chapter, so that just gives some firm time period.
Yeah, just because we help serve as a carrier of the information.
Okay. Any comments? Okay.
That's fine.
I do have one hand raised from Kevin.
Kevin, go ahead, please.
Chair, thank you. I just want to make sure that this specific time on a day still comports with 211-106 about computation of times and dates and whatnot. It may, I just wanted to make sure that consideration had been brought back to make sure everything was consistent.
I'm sorry, what are you referring to? 2-what?
211-106 is a section about computation of time and deadline dates.
Well, the head of the section says this chapter, so I don't think it would apply. What we can do is take a look at that and see if we need to be more explanatory in our computation of time, and insert that language here perhaps. I mean, we have to kind of put it here because if we're going to update this, it'd be nice to put it at the start of the plan, but we're not redoing the whole plan, so we're sort of stuck. If we want to have it in this portion, we have to put it in this portion. So, okay, well, that's something we can take a look at and see if it's necessary.
Great.
Greg Marsakin, please go ahead.
Yeah, just a quick comment on that also. So when you state something like, you have 45 days to file complaint, 45 days is 45 days. Each day should be equal to the next day, and it should be midnight. And I really don't understand why you would have to make it 4:30. It to me, and this was a deviation also from what was in a letter that I received from what the plan actually said. So it deviated the hearing notice, or I'm sorry, the complaint notice where I was a respondent
Okay,
deviated
Greg,
from what
this is new language. This is proposed language. This is not
right.
the current plan.
But
Okay.
what I'm saying is traditionally, and what I've seen throughout my life, in any kind of judicial process or any kind of process, usually if it's a day, it's the full day. So there's no cutoff to that. Usually the cutoffs are for some other reasons, not for judicial aspects. So if you've got so many days to get something in electronically, you should have till the, midnight to get it in. We're not talking about a credit card payment, Eastern Standard Time, or something like that. So that's just my opinion. I just wanted to be clear on that. And I don't know if
Right.
that'll cause a concern later.
Our issue is if something comes in at 4:30 on a Friday. We're not checking our emails at 11:59.
That's right. Thanks.
Pat?
End of the work.
Oh, go ahead, Stephen.
Yeah, thanks.
May I help Greg with that? Greg, on the state side, when I write specifications and contracts that are actually acquisitions for the state, it's actually the law for the code, we always have to specify a time for receiving documents, period, because that's a rubric. So I would agree with Pat what he's doing in this, because we don't want to drift one thing or the other. We have to have something actually on a business hour rate. People in the office, they can say received. And then we usually take them also. We take the documents, we just stamp them in our stamp machine. So it has the date, the time, everything. And that's normal process in this category. So I know that you're thinking of 24 hours and all that, but when you have to record documents, it's required you make a rubric, whatever that rubric might be, and just hold to it. So what Pat's doing actually is correct on the state side.
Yeah, and I will tell you, the court systems, when you file with the court, it has to go to the clerk and be stamped. And once the clerk's office closes, you're out of luck. It may be the same day, but you're out of luck. So what I would suggest is for the NCO itself, if 4:30 is not a good time, to suggest be it 3 o'clock or something like that. I mean, something reasonable. You want to make it 3 o'clock?
Thinking 9.
I mean, if we're going leeway, I don't think we need a ton. We would say even maybe 4 o'clock. So something reasonable, but just basically, we're just looking out for the consideration of, what are we supposed to do if something comes in on 11:59 on a Friday? Like, we're just not going to be there, and then there will be a complaint that the documents weren't received on time or whatever. But what were we supposed to do?
Well, but if you have a ruling.
Well, yeah, no. So I agree.
Okay.
I
So that was one
whether,
I said I agree.
yeah. But whether it's 4 o'clock or 4:30, not a huge deal.
Yeah, you need a realistic deadline.
So,
Is 4 better?
just as a practical matter, I guess the elections said 4:30. They may have different hours. So with the NCO, if 4 o'clock's a reasonable time, let's make it 4 o'clock.
Sure. 4 o'clock.
Is that fine?
Yeah.
I
Okay,
agree with that.
so we're changing to 4. All right. So with that said, are there any more issues with 101? And it's not the one in blue. Yeah, go ahead. Kevin, go ahead, please.
Chair, thank you. I just wanted to make sure, even if we did assign a specific time for a deadline for receipt of a complaint, does that then fully address what Mr. Mistaken said earlier about if there is an overriding statement that there must be 10 days for a filing deadline? Is there case law that says that it must indeed be a full 10 days? I just don't want to set things up for a potential conflict. Maybe that's too much in the weeds, but it's something I would think about if I was 5 minutes late.
I think if it's defined in the plan, it says you have 10 days, but it's defined at the end of the 10th day, you have to have it in by 4 o'clock, then that's what's going to hold it in.
That's okay.
Yeah. I mean, I hear this, we have a full 10 days, but that's not the real way the real world works. Certainly not the way the court systems work. So just the way it is. It is, I still think we're going to review the other part about computation of the days. That's a good point. And let's go back, we'll look at that and take that under advisement. So anyway, so I'll repeat one more time. Are there any other questions about section 101? Hearing none, we can move on. And I know last time I reviewed the video, and I think I missed you're raising your hand a lot, and I kept missing it because I was looking down. So if I do, please just.
Is there still an opportunity, because listening to what Greg had said, and also I was talking with Dylan before the meeting, I still think having a mitigation between the complainant and the person that's being complained against with the NCO before, I believe in keeping things at the lowest level before it reaches that.
We're going to talk about
We're going to talk about that?
Yeah.
Okay, because I like that idea.
Okay, well, it's actually in 101, so let's go back to where that was. We talked about it last time. Let me find it. It's actually a really, really important point.
Gary?
So hold on just 1 second, Greg.
No worries. I just found something interesting.
Okay. I'm sorry, I missed this. This was a really important point. Thank you. So we had some issue. If you look at item F, one of the options for the executive secretary and the chair is to send it assigned to a party conference, and that is C4. So the function of that goes to item F. And I got rid of the, based upon our conversation at the last meeting, the alternative complaint resolution, because that sounds a little bit too much like a legalistic mediation type of thing. So I just called it a parties conference. We didn't talk about the actual language, but that in essence what it was, and that just makes it a little less formal. The issue, and I can't believe I missed this. Sorry, I'm glad you brought that up. And it's also, there's another one too. So when we had the last item 1 through 4 initially, last meeting we had 1 through 4, I through IV 1 through 4 of F1. I broke out the last one because it's really not an option. It was just more of a setting up of the actual committee. And so I included the ad hoc language. So if a committee, if a conference, this party conference created under the subsection includes more than 2 members of a board, an ad hoc board complaint conference committee should be automatically established by the relevant board. And all requirements for the committee meetings shall be followed. And it doesn't go in depth to define who's on that committee. It's an ad hoc committee, so I would assume there would just be the complaint and then the respondent and the board chair, or the vice chair, whatever. And that way you'd have to have a committee. So that was sort of, we talked about how to form it so we could do it. And that was a suggestion. So I don't know if anyone wants to opine on this.
Sure.
Yes, sir.
I had my own question.
Yes.
So in 2, the blue highlight, or blue, the last sentence, all requirements for committee meeting shall be followed. Does that include an agenda? You want to put that
If it's required in the plan. So that's why I put if it's required in the plan. And it's and that's just because, just to let people know, it's a real committee. I mean, because you have to do it because of sunshine laws. I'd love to be able to say, you don't need to do it, but because of sunshine law, you have to do it, right?
So we got posting deadlines and.
I mean,
and it is open to the public.
Yeah, I mean, basically you're constrained by the sunshine law. What can we do?
Mm-hmm.
Ideally, it's not the best solution. The best solution would put them in a room, let them hash it out in private. But the law is what it is what it is. So we've got to follow it.
At that point.
That's right.
if it's-
Just 1 second, Steve.
So if it's a regular committee, then you are required to take public testimony.
I mean, it's not the best solution, but there's not, based on the law. Stephen, go ahead, please.
No, go ahead.
Okay.
You addressed it.
Oh,
Thank you.
I think that was Greg. Okay, Greg, go ahead, please.
Yeah, I just posted what I found a moment ago, and again, it's a slight step back, but I found it right after we moved to the next section, and I think it's important to raise. It's still a concern. I don't know why you need to change the time, and I would just leave it the day. I understand doing something if it's a Friday, you're not going to do anything with it anyway. God knows right now we're not getting any kind of, fraction on anything done timely as far as my understanding. When I send in a complaint, it's many months later I hear back. So if you're changing something, and if you look at what I just sent from an electronic perspective, yes, if you're going to drop it off.
Okay.
Oh, it's in the chat. It's in the chat.
Well, I know, but we can't see the chat, so.
I'm sorry. So what? Okay. Here's what it says. So electronic filing. So the Jeff system is 24/7. It says generally a document, general filing deadline.
Well, great. Okay, we have made our decision. I understand you're not happy with it, but we've made our decision. If we are required, if there is something in the law about having a full day, then it will be automatically changed by our corporate counsel. So it is what it is. So thank you for your input, but we've made a decision. So we have to move on. Thank you. So regarding the parties conference, does anyone have any comments, suggestions, or ideas? Okay. Well, it was. I guess it was sounded a little bit too formal before, and even though you have to, if it goes to sub item 2, it's more formal. Well, that's like I said, you just have to do it because it's the law, and we're stuck. Okay. So with that said, if there are no questions or concerns, let's go back. Go ahead, Tom.
Sorry, just one quick comment here. I appreciate the direction of parties conference because it is trying to distinguish, as you say, something that hopefully is more informal, mediative, etc. As to the F2, hate Chapter 92 as we do. The permitted interaction group is the slightly different alternative in which the participants are named and must report back. And in that regard, it is not in their own conduct open to public testimony. What their findings may be must be reported back in open meeting, etc. Then you get into a whole other issue of, well, how much more delay possibly might that be? Because when the permitted interaction group reports back on something, you cannot take action on it at that time. It must be at a subsequent scheduled meeting. But the committee got to go through all the formalities, as you say. DIG is a little bit different.
Well, it wouldn't be, the thought is it's not for action of the board for them to really take any action unless they want it. But what would you recommend based on your experience, a committee or a PIG? You want to think about it?
I'll give you my reaction.
Okay.
Based on a few things that were discussed this legislative session, in which again, the neighborhood board is a different animal, that kind of stuff. What I would put out there for further consideration, as a proposal in that regard, is be straight up with the parties conference. Deal with it in whatever that conference is intended to be, and just hold back at the moment as to trying to put it into either a committee box or a PIG box at the moment. Because of the nature in which you're feeding the discussion that results back to, and now I have a question mark, is it going back to the executive secretary? Okay. Is it going back to the commission?
Well, before we get to that question, how can you not have a box? You're having a meeting of
because you're in a
more than
complaint
two.
process.
Well,
so you've already taken kind of a left turn
So do you think maybe that falls outside the boundaries and we can call it, because it's the complaint process, it might fall outside the jurisdiction of the Sunshine Law? I mean, that may be true. I didn't really think about it that way. but it might
In
be.
some cases, yeah, and this opens a whole nother door to think
That might
about.
be an interesting
Because
question for
contested
OIG.
case hearing
Yeah, that's an interesting.
is a
point.
different part, right? And, you know, if we keep hitting that closed door of, sorry, you gotta do a committee, or you gotta do a PIG, or whatever, it really ends up defeating that essence of you're trying to have that conversation
Yeah.
among the parties in the first place.
No, that spurs
Okay.
a fantastic point. I think maybe we can, and maybe that's a question that,
Floated.
like, I'll ask OIP, because when we do hearings and such, by definition, I mean, not by definition, but you have more, well, yeah, if the parties are both here, and then you have a third member of the board, I mean, so, and those aren't covered, so yeah, maybe you're right. That's an interesting question. I didn't really think about it that way, but.
I would
think
put the
that's-
idea forward,
Yeah,
and there are other elements as we go here in the next month,
okay,
that we can do some more research on or whatever.
yeah, that's.
But I would say, stay central to the idea of this parties conference.
Okay, I
Because
think.
we're already shaving off its utility otherwise.
I agree, and I think that's a fabulous point, and it may in fact be true, so you don't have to do this committee thing, and that would be fantastic.
And I do believe that the outcome of that parties conference, there should be a report to go to the NCO and the commission, for the record.
Okay.
3 hand restraints.
Okay, just 1 second, please. Do you have any of the committee members?
Yeah.
Oh, go ahead.
So I understand this, so this parties conference is new, fairly new.
Yes,
So,
well, based on that.
yeah, we don't have this at all now, so basically a complaint may be resolved by the chair and the complainant, or the vice chair and the complainant if the complaint is against the chair. And to a neutral third party, which we haven't really defined. But I don't understand if this conference is more than 2 members of the board, so where are we setting that?
Well,
Based on the previous, 1, 2, 3.
yeah, it was under 4 where we called it the Board Complaint Resolution Committee. So this number 2 was just kind of a rehash of that in a better way that reflected our conversation in the last meeting.
So we have to reframe 2 to read like the other 1, 2, and 3.
Okay.
To a board complaint conference committee?
Well, based upon what Tom suggested, we may not need to go this route. This was only because, the thought was it would be a sunshine law issue, but because it is part of the adjudicatory process, it very well, actually, it seems like it very well would fall out, and so we could just make it, you wouldn't even need this. You would just keep with 1, 2, and 3, I think. I don't know, I'd have to look at it, but.
Well,
That makes
1, 2, and 3 is very specific, it's either the board chair or the vice chair.
Right.
3 is a neutral third party, which we haven't really defined who that might be. Or could that be a neutral third party being another member of the board? So we're talking individuals, not multiple numbers.
It'd be whoever, I think,
Either
earlier
the chair
on,
or the
doesn't it?
vice chair and
Yeah,
the
it's-
complaint.
So, it doesn't specify, so it could be whoever, and it would be appointed by the executive secretary and the commission chair would set up, assigned to a party conference, so it would have to be within whatever those folks, like you and Lloyd, agreed to, so whoever you would have as your neutral third party, be that a member of the NCO, be that a fellow board member, be that, a commissioner or whatever. Could be that neutral third party, so it doesn't specify. But it would have to be to the agreement of the chair, the commission chair, and the executive secretary.
Question is, how do you find a neutral party amongst the board members?
Well, I mean, you might not.
Yeah,
You have to go, that's why,
Because, well, when you designate the chair or the vice chair, even they may not be neutral, but by virtue of their position as chair or vice chair, they're named as who would resolve the complaint according to this language. And a neutral third party, whoever that might be, can also be brought into this complaint
well,
resolution process.
they should probably have or after the end of it. It just strikes me. So it depends, it could be the board chair, it could be the vice chair, or if they're interested parties to the extent that, like I said, the executive secretary and the commission chair doesn't feel like they can be unbiased, it would go to just.
I think just to protect the situation is that third party should be a member knowledgeable from the NCO, because the NCO would have the knowledge on the issues, especially with sunshine law on the plan. I just say, because it's hard. We have infighting going on with the board, and you got issues between the board member and the chair. You got to come in with somebody else into this situation.
That's a neutral third party.
Yeah, and to me, the trusted agent is the NCO, because they're the experts on the subject.
I don't know that all the NAs are experts on this subject.
But I don't know, no, I'm not saying an age, I'm just saying, from the senior leadership of the NCO, because, whatever, it all depends on what believes to be violations and all that kind of stuff. But there needs to be a third party in there knowledgeable to be able to help resolve the situation and get people to understand, okay, was this a big deal? Was this really a violation? Okay, and if it was, okay, let's move forward. How are we gonna do this? And how are we gonna prevent it again?
Well, the thing is, once you define something, then you're going to be stuck with it. So if you want to define it as a member of the NCO, that's fine, but then you're going to be limited in the future. It's always got to be that.
Then the only other thing I think of is having a commissioner.
And that would be you preclude yourself, but what if you have an ex-commissioner that you think, like say not say he's volunteer, but someone like that, that's the problem. Then that person would not be able to fulfill that.
They've, for example, served as hearings officers in Catholic meetings, correct?
But if you're not like an active commissioner or you're not actively in the NCO, then if you put that language in there, you wouldn't be able to serve in that capacity. So that's why I'm saying if you leave it vague, then it allows the executive secretary and the
We can leave it 1, 2, and 3 as it is, and not even need the 2.
2 would be if it concerns the vice chair. So you're right. Well,
Oh,
if
he
you consider
meant
the vice chair
subsection
neutral
for
third
instance.
party.
The next section having to do with the 2 members of a board.
Yeah, we don't need that.
Oh, no. Well, I think in light of what you said, we probably don't. And I didn't think about it may be outside the sunshine law. So yeah, I would think number 2 would be completely stricken. But it would be good to get clarification from OIP that that's actually the case. But yeah, after you said that, I think it makes a lot of sense that we would strike subchapter or subpart 2. Okay, so I would add or to these. That's kind of how I read it and I forgot to add it. So that gives, it can pick this or that or this, that's the only way it makes sense. So hopefully we can strike 2. Okay. So any other comments about the parties conference? Are we all happy about that?
Oh, I just had 3 hands raised online.
Okay, is there a committee chair first? A committee member first?
No.
Okay, well then, go ahead.
Let's start with the first time speaker, Michelle Matson.
Michelle Matson, please go ahead.
Well, it's jumping into the background again, so I'm sorry you can't see me again, but I just have a couple of things to say. I've heard something that really concerns me about a board committee or a PIG hearing an issue that has to do with the neighborhood board or a member of the neighborhood board, this needs to be an objective forum. The contested case with a hearings officer would be the most objective. OIP would be somewhat objective. Just as an example, regarding the committee or a pig, astonishingly.
Well, okay, excuse me, if I could just interrupt, please. We've actually decided to drop that provision. We think that OIP will say this is an adjudicatory matter, and so it does not fall under the confines of the Sunshine Law. So that is no longer under consideration unless we find out in the future that we have to do it this way. So we will not be doing a committee or a pig.
Well, then why was there so much discussion about it?
Well, because we thought we were going to have to, but we've kind of come to the conclusion we don't have to. So that was the discussion we just had.
Wasn't that clear? Sorry.
Okay. Well, sorry. I mean, are you following what we're saying?
I didn't hear a vote or anything on it.
Well, it was sort of a consensus. And so we didn't formally vote on the proposal, but it was the consensus of the committee that this part, we now feel it's unnecessary. So we dropped it.
Okay, well, you've summarized that in a very excellent way, and I really appreciate it. And it would have been very clear if we had heard that previously. Thank you.
Thank you. Are there any, did you have a follow-up question? I'm sorry, or was that it? Was that it?
No, it's a concern of, it's really concerning all our boards and a certain lynch mob mentality that happens to be moving forward in one board. And I think that may be for another forum.
Yeah, that's actually, if you have specific issues with a board, that would be for the commission. So thank you. Thank you for your input. Claire? Kevin Lai. Go ahead, Kevin.
Chair, thank you. I may have had a similar question as to Ms. Matson, but in hearing you're referencing now that F2 has essentially been stricken and not F1 little 2. So
no, it's the F2, the Western Arabic numeral 2.
Okay. I think that's good. I think there were lots of other issues why that was probably heading in the wrong direction. But a question then, what will replace that? And then prior to that, F1 little 3, this neutral third party, I heard comments about it earlier. Will that be a list of eligible folks or types of folks who's maintained by the Neighborhood Commission office? How will they be known or confirmed to be independent or neutral given the total array of issues that could have come up in a complaint? And then ultimately, just really brief, for F1, is there some logic prior to F1 that's pointing to F1 for which the executive secretary and commission chair would not choose to seek to resolve the complaint? And the point there is, why is the word may included in F1?
Okay, you should really ask your questions separately or else they won't be. I mean, just as a comment, because sometimes it gets lost if you ask in a series. But so I'll try to address everything if I don't. Let me talk about the qualifications of a neutral third party. As far as I know, a hearings officer, the qualifications of a hearings officer is not defined in the plan. So I think in just the conversation we had just a couple minutes ago, why it may not be prudent for the commission, or for us to suggest that neutral third party should be defined. Because that's hard to actually put a definition. You could restrict it to certain categories, but then you might find that there are other people who are very qualified that you might not be able to tap in that position. So I think we're going to leave it the way it is. Okay, so that's as far as the neutral third party. Correct?
Right.
Okay, so as far as if you're referring back to C, what is it? The party conference, C4, where it
Or,
says
yeah.
assign, shall assign. Yeah, these are all or, so essentially it's alternatives. So is that what was your question exactly? You said may versus shall.
Right. If we get to F1, where we're going to discuss this, why is there the
okay.
option that they may not want to resolve the complaint?
That's true. I see your point, but I don't know if like shall is going to really change it because it's an optional procedure. It's more of saying if this is chosen, they may, I don't see a problem with that language.
I don't see a problem with it because the parties conference may determine that, hey, this is serious stuff. We can't handle at this level. It's got to be bumped up. So maybe resolved by taking it up to the next level.
Yeah, I would agree. I think shall it would probably be confusing too, because they would look at F and said shall seek to resolve the complaint, and then people are going to be like, well, then you have to do a party conference regardless of everything else, and it's an optional procedure. Okay. So I'm sorry. Did that answer all your questions, Kevin?
Yes, sir. Thank you.
Not too happy with it. Okay.
Greg.
Greg Marsakian, please go ahead, Greg.
Thank you. I have the same concern that Kevin did. I understand exactly what he's referring to. And I also see that it's problematic when you're throwing three options there. Again, the third party, in my opinion, would be a third party mediator, a neutral third party, not anybody on the at the NCO where I see bias, and not anybody that's on the commission where I also see bias. I'm sorry to be, honest and upfront with you, but that's what I see and others see. And when there's even the potential for bias, then you want to be careful with that. But when you say that may seek to resolve the complaint, again, if you're going to have a procedure, it should be defined, and you should have a procedure that's clean. And when you give options, and for some those options are utilized and for others they're thrown out the door quite often, then there's clear bias. And when you have a procedure that introduces the ability for further bias, which to me, this whole process is just, introducing additional opportunity for bias against complainants that might have valid complaints. As Ms. Matson said, the lynch mob mentality, where unfortunately that's where I'm at my board, where it's a lynch mob. And it's not fair to the board members. It's not fair to the process. It's not organically evolving. It's, in my opinion, this procedure that you guys are putting forward is because of not being able to simply address the complaint process that you had, which in my opinion isn't that bad if it was followed, but it wasn't being followed properly. So you're trying to reinvent the wheel. And if you're going to have a mediation, have a mediation. If there's some money to put into that, pay for, Mediation Center of the Pacific, pay into it, or the DPR, utilize their services and do it that way. The last thing I'll make a quick comment on is having the vice chair, chair, and a complainant who's a board member. 3 people on a board participating in a discussion on a complaint. Is that even allowed by sunshine law? I don't know. That's just another thing I visually see here. But to me, this is just ripe for problems, further pushback. And I think at the end of the day, it's going to create more animosity, and people are not going to want to join boards because of this, because they're going to see that there's like an unfair process. My opinion. Thank you.
Okay, thank you. Tom, go ahead.
Thank you. As I look at this language and listening to the comments, I think it actually gets closer to the point and avoids the problem when we were talking earlier, not tonight, but earlier in terms of, we want to include the board somehow in this. You guys are having a problem, let's take that discussion to the board. Well, this is a subset, which I think is more honed to actually trying to have that resolution discussion, whatever you want to call it, between ideally the leadership, or at least the main leadership of that board, and the particular parties, whatever gave rise to this, I hate to use the word complaint, right? And then have that feedback come right back into this process through both, the way it's set up at the moment, both the executive secretary and a commission, or I should say the commission chair or designee. But in that regard, you've already focused better, in my opinion, where this preliminary discussion can be had as compared to, well, no, we want to put it before the full board. You guys caused the problem, which had even more problems.
Yeah,
Okay.
the committee didn't want to do that.
But we do want to have that discussion, if at all possible, do we really need to do all the rest of this contested case hearing stuff? Or can we approach it directly and have that feedback come back from the parties themselves to the NCO and to the commission? So I think the way in which this is boiled down now, actually is very close to the mark.
Thank you. Good. Larry?
Chair, what I'd like to talk about is, I do see the situation, the scenario, where you have a board member and you have the chair, where the complaints are going back and forth. And I can see that where a third party is definitely going to be there. Now, Greg, you said everybody's gonna be biased. Well, I'm gonna tell you, there's bias everywhere, perception-wise. But I'm gonna tell you, there are individuals that will take you up on that, say that they believe that they can be a third person in there to help mitigate the situation and be a good mediator. You gotta have trust, okay? If you ain't got trust, you're in the wrong place. So I do think that when that situation occurs, when you do got a board member and a chair and that's a disagreement, that third party is vital. And we need to have somebody that is unbiased to go in there. And I know from a fact, from a commissioner standpoint, I trust all the commissioners that are here to go in, whether or not they got the experience to be able to help mediate. And I'll be honest with you, I don't have a lot of faith in going outside into the city's mediation process, because I've been there and it sucks. Okay, that's it.
All right, so I think the committee has kind of spoken and resolved this. Are there any other hands? Okay, so with that said, we will move on. And when I say move on, we're going to actually jump to subsection E. And I apologize, I missed this the first time. There was a comment last time, and I think this was Kevin Lai, who asked about how, if, wait, what was that? So if the secretary, the executive secretary and the board chair, or the commission chair, dismiss a complaint, it would not go to the commission. So the complainant may appeal, and that's what item E is about. So let's take a moment and just read through it. And it says, for a complaint dismissed pursuant to 218-101C2, which is, as I just said, dismissing the complaint, a complainant may initiate an appeal upon filing a complaint dismissal appeal. That's a tongue twister, I know. With the commission office on a form provided by the commission office. Okay, this needs to be a little wordsmith, a little bit better. Within 10 days after date on notice of said dismissal. So in this case, the NCO would just create a form. It would be 10 days on, that would toll on the date that's on the dismissal form, and hopefully it'd be sent out in a timely manner. I guess maybe that's a point of contention, but anyway, so it's just providing a method for the actual appeal process. That probably could be wordsmith a little better, sorry.
But we get it, we understand.
But that's the concept. Are there any questions? Tom, go ahead, please.
Quick question, is the appeal of the executive secretary's dismissal
The executive
Directed-
and the commission chair. So the two would confer. So under C, the two would confer, and then they can dismiss.
Okay, and after that dismissal, the appeal goes back to the same individuals or goes to the commission?
No, it would go back to the individuals, and they would be noticed of the they'd have notice of the dismissal. In fact, I'm not, it would be both parties would be noticed of the dismissal. So if you look at D, both parties would be noticed. And then so with the dismissal, the complainant has the option of appealing that dismissal to the full commission.
I was wondering where, from here it goes to the commission.
But it has to be an affirmative appeal. Like if the complainant doesn't do anything, then the dismissal just takes full effect.
What do you mean the complete doesn't?
Well, the complainant has to actually initiate an appeal. So in other words, if the complainant doesn't initiate the appeal, the dismissal stands. Does that make sense? Okay, so what happens is, say you get a complaint, you get, the commission gets a complaint. You, as executive secretary, you review with the commission chair, and you say, no, I don't think this is valid, let's dismiss. And so it actually is dismissed based upon your input. And that is sent back to both parties.
Right.
And the complainant then has the right under this subsection E to appeal. And so that's what creates the appeal. And if they appeal, it goes to the commission. If they do not appeal, the dismissal stands.
Well, it's both the respondent and the complainant, right? Not just the
Well,
complainant.
It should be the complainant, the respondent. Why would the respondent appeal?
That's
I mean,
what it
I
has to dismiss.
Oh, it doesn't say that, does it?
It does.
It just says they get notice. It doesn't say he gets the right, the respondent gets the right to appeal.
The complainant may appeal.
Yeah, I mean, it doesn't make sense for the respondent to
Right.
appeal. So,
Someone's
okay,
guilty.
does that make sense to everybody here? We're good to the questions online in just a second. Does that make sense to everyone here? So do we have any committee members that have their hands up? If not, then go ahead. Kevin Lai.
Chair, thank you. If I understood Mr. Heinrich's question, it was to specify to whom the appeal of a dismissal is addressed, because the complainant now is charged with, within the next 10 days, collecting new or additional evidence that was found not to be satisfactory in the initial review by the executive secretary and or the commission chair's designee. For that reason, in C2 up above, we need to insert the clause with written explanation to complainant so that there is at least an understanding of why the initial filing was dismissed. Otherwise, it's unknown why, and then you're kind of shooting in the dark if one does file an appeal. I'd appreciate that if that change could be added as a comma delimited clause in C2 following the words dismiss complaint.
Okay, the committee can suggest that. I'm not sure a lot of times that's necessary. Okay.
Not that I want everybody to appeal, but I don't think there is a need to have new information.
Yeah, that was the other part.
It was just, I disagree with the decision, and I want the bigger board to hear it. You know, I don't see it as needing to, the person needing to get more information or a different type of information. So,
Right.
I mean,
Does that reeks of a certain amount of arbitrariness, though, doesn't it, Chair?
No, I don't think it's arbitrary. I think it's just the two parties. These two parties would say it doesn't, we don't feel that it rises to the level of something should go to the commission. And the party that says, yes, it should, the complainant, I don't see where, they should or even actually be entitled to submit additional evidence. They're just
Okay, well-
appealing the.
Okay, so then if the appeal goes to the full commission, then is there an assumption of non-bias of the full commission from the initial review of the complaint so that the larger body isn't tainted by opinions of the chair or of the executive secretary prior to presentation of the appeal by the denied complainant? That's what I would hope could be engineered and codified.
I I would think that would be difficult, and if the commission, I mean, you're always gonna have the recommendation from the executive secretary anyway. So it's probably not gonna really change anything, and the commission is gonna should be able to review everything that's in the complaint itself, each commissioner should, so you're basically getting the same process that we have now. Does that make sense, Dr. Locke? Anything further?
Yes, sir. Thank you.
Thank you. And one more? Greg, go ahead, please.
Thank you. So, in looking at this, it's completely rewritten. So one of the sections here, H, for complaints referred to the commission for review, respondent shall file a written response to the allegations with the commission within 10, you change that from working to business days after the date notice of the complaint and referral to the commission was sent to the respondent. I'm not going to read the rest of that, but when you look at the original wording for a complaint and the response time for a complaint, it's 45 days that's given to the respondent. 10 business days is a very short time to respond, especially if somebody's busy or traveling or they've got things going on. We're also pushing this outside of the standard process that we have now, so it's getting delayed, and then if it does go to commission, you're giving it a 10-day stamp to respond to. That's a concern in itself. A lot of the other things are concerning. I'm not going to go into all of it because I'm looking at this process and I don't see it as a better. I see it as being made to add more bias, as I've already said. So I'm very straightforward when I say that, and I differ on where you're headed with this. So that it's fine that we're two sides that are differing, but that's a very important thing. If someone has 10 days to respond to the complaint to the commission, and then the last thing I'll say is, where is the process previously for the chair, the vice chair, the meetings, establishing the meetings? Where is procedurally this outlined within, and maybe I missed it, but where is it outlined here? How is all of this going to work if you're trying to, mediate, adjudicate this early? Which I'm all for, but not if it's not done properly.
Okay, well, let me respond to what I think you said. The 10 working days are 10 business days, so essentially that's 2 weeks. It's not 10 days. And it could be more holiday dependent. Secondly, as far as where this procedure, this parties conference is outlined, it's F1. I mean, I'm not sure what you're asking in that regard. It's a new creation, if that's what you mean. It's not outlined in the current rules or the current plan, if that's what you're asking.
Yeah, I realize that, but again, it was 45 days previously to respond to a complaint. So you had 45 days. If someone's, filing a complaint against you, you have to go look at the meeting, review the video, watch it. It could be that you have to watch the whole meeting 3 hours, 2 or 3 hours, and then you have to provide a detailed response. You might want to have a chat with an attorney. I don't know. I mean, the way that this process seems to be going, it seems to be headed down a path that you are desiring litigation. And, it's just, there's a lot to do. So, it's 45 days to file the complaint going back, and then you're giving the respondent 45 days. I guess that's fair. You could say 30, but to make it 10 business days, I get it. It's 2 weeks, so let's call it 14 days. Maybe. Then where is the fairness in that? You're cutting it in less than half,
Okay.
Something's not right with where you're headed with this whole process.
Okay, let me let Larry respond.
Yeah, Chair and Greg, I just want to say that, you missed earlier meetings where we discussed, we figured that it was broke as it is right now. 45 days is too long to wait what we had. And the problem is, this stuff festers on week after week after week, and it starts to be old information. We want fresh information, be able to act on it in a timely manner. That 10 days is 10 working. So you said 2 weeks? Well, really, those 10 working days is the 2 weeks. But the other thing is, everybody here is human. If you came in and says, I gotta go because my grandmother, she's ill back in the mainland and I'm gonna be gone the next 2 weeks, you send a letter to the commission saying, hey, I need a waiver. Can you please bump this meeting date, my hearing, to the right? And you know what? We would do that for you. Wouldn't we do that? When somebody has a special case like that, their parents passed away, they gotta go to the funeral, we're human.
Yeah, I think this actually is gonna come into play on section A of 102, so hold that thought and we'll get there. So are there any more comments? I think we've kind of, and this is the big section, it's 101, yeah, go ahead, Richard.
You know, the response to the complaint, if it's referred to the commission, why wouldn't the complainant and respondent respond to the complaint before they go to even, or we just talked about the conference? Because going to the conference, if both parties deny,
Well,
allegations, for example, if the respondent denies it, it's probably good to know what their positions are before going to the conference.
Well, the third party's gonna have their comments because they couldn't mitigate it.
yeah, so under the plan, under this proposal so far, if it goes to the parties conference,
Yeah.
it will not, before the conference, it does not require a response from the respondent.
But the question is,
Should it?
well, yeah,
And
it's a
that's
question.
a good
Wouldn't we
question.
want some kind of response?
Well, but I think the thought was,
Within
we
10 days
wanted
of the
to sort of
filing.
streamline the process.
Yeah.
And,
It's the filing of the complaint right now, right?
I mean, that's a valid
Yeah.
point. It depends on what the committee wants to do.
Because we're crunching the time down, so if they respond and they don't agree, in the parties conference, under those provisions, then they can, bring it to the commission.
Yeah, I mean, it's totally up to the complainant. That's the
Right.
thing is, the power is with the complainant. If the complainant does not feel that the meeting satisfied
Right.
them, then, I mean, that was kind of the thought was that then the respondent would have to formally, write up a response. Because essentially, if the complainant is satisfied, we're hoping they're satisfied, but if they're not, it's within their court to make that decision, and then you can require. I mean, that was sort of the planned out thought, but if the committee wants to go a different direction and require the respondent to respond before that type of meeting, so be it. Does that make sense? Okay, I think I've lost you.
We get what you're
I know,
saying.
but I think I've lost Lloyd. So right now, if you go to this party conference, the complainant has to file the complaint,
Right.
obviously.
To get to that.
But the respondent does not have to reply before the party conference.
Right.
Yeah, and so the question becomes is, should the respondent have to reply before the party conference?
Yeah, because quite often what we've seen with respondents is that they just deny the complaint, right off the bat. So it's not like they're gonna take tons of time to gather all of the
The
evidence.
easiest answer would just be yes, they should respond before. And the reason why is because depending on when you set the date for the party conference, well, then that's gonna dictate like, well, when does the person have to respond by? And that just makes it confusing.
Well, that's actually covered in the hearing aspect. There are additional, and we probably need to plan it out, need to make sure all the dates fit. Maybe, and I have to say, I haven't done it on paper, but there are some additional
And
time.
if
once we set the hearing
eventually
date.
the complaint does go to the commission, and at that point, they can provide all, documents and witness lists and all of that stuff.
Well, I mean, if it's the will of the committee,
Yeah, that's just a question.
if it's, I mean, that's sort of a subjective, I don't know, there's a right answer.
I think it's important for the third party, before they sit down in the conference, in parties conference, to be able to see the views of both individuals. Because when you get in there to talk about, okay, what happened at that meeting? And then the next step is how, what could be mitigated out of that? You know,
Okay.
because obviously there was a disagreement over whatever the issue was. But the other thing is, the chair runs the meetings, and the chair might say, you know, maybe firm and say, I'm sorry, I'm not changing the way I'm doing business. It's the way it's gonna be. But then the third party tells the chair, says, you really need to look at this because you can't complete your meetings as it is.
Okay, well, then we can, if it's the will of the committee, we can fit that in. I'm not sure where, but yeah, I'll look and can fit that into here. Yeah, and just require the respondent to respond. Okay.
Chair?
With that, well, hold on just one second. Tom, go ahead, please.
Thanks. Just a question, as I keep looking back here, how much time is given for the parties conference? I see the delegation to the parties conference, but I don't see
Timetable.
within 30 days or something, this parties conference must take place, you know, and report back or something. I'm missing,
Yeah, it's
where's
not
an
in
end
here.
time?
It's not in here. We have to create it.
And I recommend we stay with the same timelines that we got, the 10 business days.
It's 2 weeks, so, okay.
Nip it in the bud, quick.
Okay, so we're trying to, okay, I'm sorry, so, Claire Santos, sorry, go ahead, please.
Thank you, because this is the second meeting where my hand was up and you decided to move on. Is that conscious bias or unconscious bias? My point being, you can't police yourself. That is ethics 101 that I'm surprised Dr. Lai didn't bring up. I'm even surprised there are board members on the commission because you really cannot police yourself. That being said, it is what it is. I am all for any plan where you sit the two people down informally and talk it out and see if you can't reach consensus and move on without a whole formal crazy process. After that, because of bias, whether conscious or unconscious, and there are people on the commission who have personal friendships with people on boards. So you're human, you're going to have your biases, whether you are aware of them or not. It would be best to bring in a third objective party who is not related to anyone on any board or working with them or having personal friendships, because, you know, commissioners should recuse themselves if they've got personal friendships with people involved. So I just want to introduce that concept of ethics to you folks. You really can't police yourself. And I think beyond an informal sit down, really a third party should be brought in. Thank you, Chair.
Okay, well, I understand your point about the policing yourself, but the idea is we want to allow the boards to have the first look or the first crack at solving the problem. And like we said, the complainant does not have to accept. So if there is bias or something, the complainant can say, well, the process didn't work. So I don't see, you know, how that really applies, because there's no finality with that procedure. The first part I did want to address about calling on you, I would let you know that it's very difficult to see your hands sometimes for the online participants. And yes, I would call on you if I see it. I hope it's not. So if anything, given the two options, that maybe it's unrecognized bias. I can't remember how you said it, but no, I don't think there's any bias. We just missed it. And
It's
in the
conscious
future,
or unconscious bias.
Oh, okay. Well, in the future, if we do say we're moving on, you can say chair. And
Yeah, that's
because
what I just did. Yeah.
And we called on you. So and I appreciate you waiting a moment until we resolved it. But I did get to you. So that's what I'm trying to do. So if I do miss you, please do that again. I'm not trying to miss anybody. This is for the public.
Yeah, I just wanted to introduce ethics 101 to how to conduct these sorts of things without personalities getting involved, friendships getting involved. The individual neighborhood board chair, I don't know if they have that responsibility, that duty to sit the people down and say, let's work this out.
Okay.
You know, you have steps in process, but to keep it as clean as possible and keep those biases at bay as best as possible and hopefully resolve it quickly. Kind of like in a jury room, you know, just have to kind of help people find that happy medium and come to a consensus. Thank you, Chair.
Thank you, Larry. And
Yeah,
Tom.
and Chair, and Claire, we hear you loud and clear when it comes to ethics. And what would think of all of us, whoever is asked to be a third party, you would think, and also the question be posed to the third party, do you know the two individuals that you're gonna be mitigating with? And is there any bias whatsoever? And then the other thing is recuse yourself, because if there is, you get somebody else that don't really know. We totally agree with you on that.
So, Tom, go ahead, please.
Thank you, Chair. Chair, you just said something a minute ago that I don't see written, and could just be me.
Okay.
And that is looking at F1, for the parties conference, what if the complainant refuses to participate? You just kind of made that statement of they may refuse. And yet I don't see that declination option, if you will, for the complainant in writing. So what happens if they do decide not to participate in a parties conference? Because damn it, I want to hear it. So I don't find it, I just point that
It should be
omission.
required. I mean, come on. I don't know. That's a good question. I'm glad you pointed that out, but do I hear you?
And we've had this situation in the past that at previous hearings where the respondent did not show up. And right there in the hearing itself, that sends a clear message right there to go ahead and dismiss the situation.
Well,
Or because it was a serious complaint that was from the complainant, that the commission take it up for other actions.
Okay.
I can see how you could do that if you wanted. For example, after 3, number 1, say number 1 withdraws their complaint, the complaint process shall be concluded. So if a complainant refuses to participate in this parties conference, then the complaint is deemed dropped.
But we haven't said that.
Yeah, I know we haven't said that, okay, but that's how you could possibly do it. If you wanted to basically give this a try first.
I mean, they have to participate in the hearing process. I mean, practically speaking, if they want to be.
But it's not fair to the complainant if it turned out it was a serious sunshine law violation. You can't just dismiss it.
Well, we're going to follow up on the sunshine law part of it. Hopefully, because it's adjudicatory, it's not
The personal attacks, those kind of things.
Okay, I'm not following you there.
I'm just saying when it's a serious situation, you know, the commission needs to act on the respondent. You just can't not show up for something. The complaint was a serious complaint against them, and it needs to be followed through.
Well,
If it was nothing serious, yeah, drop it.
well, but we have to remember that this is an option by the executive secretary and the commission chair, and hopefully they choose wisely. You know, if the circumstances do not really fit where this is a good idea, you would hope that the individuals in their positions would make the right decision. And at the end of the day, you have to trust someone to make the decision, you know.
As an alternative to having the complaint just dropped, the other alternative might just be put it to 2. If the complainant refuses to participate in the parties conference or is not satisfied with the result of such meetings, then you proceed with going to the executive secretary and eventually to the commissioning. Then executive secretary decides that. So basically, it'll move on to hearing. So they could you could let the complainants decline to participate altogether and go basically straight to a complaint before the commission.
So you suggest either party can decline to participate, and then it would just go to the commission for a review?
Well, that's another alternative.
That's, yeah, so. I mean, my view would be to require the complainant to participate, both parties to participate, but
Well, then you have the other one, if they decline, the complaint is dropped.
well, if the complainant refuses, if the respondent refuses, then then it goes, I would say, go to the commission. And the
Yeah.
commission obviously take that into the account too. I mean, it just depends on what the committee, the feeling of the committee or the will of the committee, I would say. Any thoughts about what we should do?
Well, if you file a complaint, why would you not
I mean,
follow
we
through
have-
with the process?
We can take it, I'm sorry, Dylan, what?
If you filed a complaint, why would you not show up to this mediation?
I mean, well,
It's happened, in the
obviously,
past.
Well, no, so far there is no mediation. This is
Okay.
the new idea, right?
yeah, and we don't call it meetings.
Yeah.
But, okay, since there's no huge desire, why don't we think about it? And next meeting, hopefully someone will propose something, I'll propose something, and go from there. And
Like, we're not calling it mediation, but in the mediation process, if the parties decide they don't wanna do it, then,
well,
they can opt out.
well, in the court system, they can.
Well,
You have, it's required. You don't have to accept the results, but you gotta go.
well, it's the thing, is that you don't have to accept the results, so, but people going into mediation, if it's not court ordered, they do have the option to decide not to. For example, other kinds of complaints, neighbor, you know, the parties have to agree to go to mediation. But if anybody declines, then, you know, they can take whatever course of action they feel they should.
Tom, you know,
I appreciate you bringing that up, because that's what was playing in my head is the judiciary's process. And ultimately, the key is, if this was not resolved either by failure to participate or being too unreasonable by a third party, the judge's review, then in this way, the commission being the judge, it's a matter that you take that into consideration of you're prolonging these proceedings unnecessarily. This could have been resolved earlier. That is now held against whoever that party is. So it does come back around in that regard, ultimately for the commission to consider.
okay.
Two on Lauren. Let's go back to Claire. She still has her hand raised.
Claire, go ahead, please. Or do you still have your hand raised? Did you have a question or comment?
I apologize, I forgot to take my hand down.
No problem. No problem. Kevin.
There you go.
Chair,
No
thank you.
problem.
Just a quick clarification. In C3, F3, and even H, when there's reference of a review, is that distinct from an actual hearing itself? Because it seems
Yes.
like, so there's just another layer that the complainant must go through to actually get to a hearing. It seems like there's a lot of engineered layers for potential rejection, and each of those layers, are they eligible for review as well to the full commission level?
Because not every complaint rises to the level of a hearing. That's the thing. The commission can dismiss without going to the whole hearing, for instance. I think that's probably the only time. But so that's why there's a distinction between review, and that's what we do now. Like, for instance, every time a complaint comes to the commission, we don't initiate a hearing. So that's why there's a differentiation between review and hearing. That make sense?
Agree, but currently, it is the executive secretary who's performing that review, yes or no. If he thinks it's worthy, it goes for a complaint process. Now you've got executive secretary can review, chair of commission can review, they put their heads together. If they're not concordant, there can be another meeting that can be sent to a review. It seems like it's just stacking against the complainant to have his or her just time, if you will. That's just an observation. And my other question is this: the meetings.
Let's go one at a time, because
Yes, sir.
it gets confusing a little bit when we try to break it up too much.
I'm conditioned by our board. We have to get everything out of our mouth in 1 minute or less, so I apologize.
Okay, no.
And you're doing a great job.
You do a great job. So, that level, there are distinct levels of review. So you do have that initial review. It's a joint review. So that's only counts as one. Then there are various options. One of those options, or a lot of them, not a lot of them, I should say that, but if it goes whenever it goes to the commission will then review. So you have a whole nother review of the whole commission, and we will decide how to dispense with the complaint at that point. So yeah, there are essentially two reviews, and it could be more, because if you go through that parties conference, it could be then sent back to the executive secretary and the commission chair to adjudicate further, or to make that decision to review further, let's say. At that point, they would most likely send it to the commission, because what else are they going to do? I don't think they would dismiss, because if they found it valid to go to a conference or a parties conference, then I don't know. But that's essentially what the structure is. Does that make sense?
It does, but is there defined the ultimate limit of the appeals process? Who's the Supreme Court in this scenario?
The commission. And in theory, it's not the Supreme Court. It'd be like the state Supreme Court, maybe, in the sense that, yeah, you can actually go adjudicate this in the circuit court or whatever, I assume. But essentially, it is right.
Okay.
Right. So it is essentially the commission.
Chair, if I may, yes, I appreciate that explanation. I think, again, it seems like there are additional burdens now compared to the previous system. Maybe, again, that could be engineered that way, but it seems like there are more chances for a complaint to get not considered than it would be to be considered, but that's the way the process is. I'd love to see the final language when it goes out for review. But regarding the meetings that are to take place. Sir.
Okay, well, let me jump in and just say, I can understand what you're saying. If you're a complainant and you want to streamline the process, maybe this is not in terms of time, but the process itself. Yes, this is a little bit different. But from our perspective, at least from my perspective, this provides a better resolution of complaints, a more effective resolution of complaints. So yes, it adds it adds more complexity, so to speak, but it allows, the general thought was to have the boards participate, and we feel that's important. So.
Okay. My last point here for E3 is this. Again, I advocate for the board at some point running some desktop scenarios, taking any of the previous complaints from the last couple of years and just assigning parties to represent complainant and respondent and just model it out to see how this goes. I can think of a few complaints that may throw a large wrench into the works, and I can propose those to you later on. But the meetings that are to take place, whether with a neutral third party, how will it be determined if they are adequate, sufficient? What are the expected outcomes as far as the report that will go to the executive secretary? Minimum criteria, they need to be referenced. How do we know that what's happened is a fair shake to, in this case, both parties?
Because, well, if the complainant's not satisfied, it can go to the commission. So, and as far as what is included in the report, that's not defined, and I don't know that the committee will attempt to define that, other than just a general recommendation. So, with that said, I hope that answers.
Thank you.
I think Tom is next, and then we'll get to Greg. Go ahead, Tom.
Okay, thanks, Chair. Just a quick comment on, we've been spending so much time, understandably, on the procedural framework, if you will, that we're not giving also that other consideration to the substantive review that is taking place at certain stages, starting with intake with 218-101C, which is both the executive secretary and commission chair or designee, and then several other points of review. I think, and I'm not going to pass it out, but again, the reference to whether it's ethics commission or OIP, where there's points of advice of providing counsel or whatever. Look, we've seen this one 14 times. We don't need to have a full contested case hearing. How do you counsel the complainant, if you will, that maybe hopefully leads to that withdrawal of the complaint, whatever. But in this case, it's a matter that if at these various points of substantive review, that yes, there's a basis for a complaint, it should proceed in the process, or no, there's really not enough there in whatever way, then there are these earlier off-ramps. Because ultimately it's trying to deal with, let's arguably say there is substantive merit to whatever comes in, but then upon further review, it is something that either can be dealt with in consultation with the executive secretary and or commission chair, or at the parties conference or whatever, and still truncate what has been such a damn long process, right?
Okay,
Thanks.
thank you. Greg Marsakian, please go ahead.
Thank you. Yeah, I echo what Kevin was saying regarding process, and what I'm seeing is there's other layers that are added, but within those layers, there's no defined sub-process, in my opinion. And I gave the example earlier. How does, say the complaint is against the chair by one of the members of a board, and you're suggesting or referring that board member have a chat with the chair or the vice chair or the three parties together. Is that going to be clearly documented as far as procedurally how that works? The time frame? Is it a teleconference? Is it via WebEx? There's so many layers to this onion that the more you keep bringing into it, the stinkier this onion's going to get. It's going to be a rotten onion at the end of the day. So the layers that we're going to have to pull back to get to a very simple process, which should be something simple. As I said a few meetings before, if we're adults in the room, it doesn't seem like that happens quite often. At least with my board, there doesn't seem to be a lot of adults. And if we're adults in the room, we can work together. We can address issues. But when members come to the NCO for help, and then this is what happens, there's committees formed to change the process, add layers of, you know, I get a layer that's a good layer, but this is a cake with really weird layers. If you've ever watched the Friends episode with the layers of things that, I forget, there was a dessert made. I'm not sorry to analogize, but it's layers that are really causing problems, and it's not going to make this process better. And at the end of the day, one last comment, the hearing process should be open to the public. Why was the hearing? All right.
Okay, well, we haven't
We'll
gotten
get
to
to
that
that in a
yet, so
moment.
when that
I'll
comes,
hold
sir.
that comment. I'll hold
Thank
that
you.
comment. Thank you.
Thank you. Go ahead, Larry.
Yeah, Chair, and also for Kevin and Greg, I can tell you that if I was asked to be involved as the third party, and I've got a chair and I got a board member, and I've listened to both sides of the story, I've watched the video, and then I provided constructive criticism. I can tell you for a fact there are board members that can't take constructive criticism because they felt they have not done anything wrong. And in that case, the third party has failed to be able to bring closure to the situation, because you got two individuals that just won't budge. They just can't take constructive criticism, and it's a failure, and it has to go to the next level. But I can tell you there are a lot of board members that do listen. And especially when you have somebody that's been involved years, some of the commissioners and whoever the third party is, they've got experience in those cases. And they see the solution, and they see how people can work together. But you've got to give in, and some of those board members won't, but there's some, I hear you, third party, next meeting. And of course, when you can have the board, after that meeting, the solution that you want is both shake hands afterwards and you get to the next board meeting, because we wasted all this time bickering when we failed the public, when we should have had 3 resolutions done out of that meeting. And what it was is because people talk too much. The chair's got to control the public. the same people gotta stand up every time for everybody that comes up. So every scenario is gonna be different, like Kevin said. You can build these various models, and the model that you're gonna see fails is when you got people that don't take constructive criticism. That's it.
Thank you. Okay, so we're kind of nearing the time that we should call it an evening, but I would ask, are there other comments on 101? And maybe we won't take it up if there are.
Chair.
Oh, yes, go ahead. Go ahead, Commissioner Melendez. Steve.
Yeah, just to comment, Chair Pat, is that the more I go through this and the more I'm listening to the testimony, I'm going to circle back. I'm going to go roundabout to what we had talked about last meeting about, and we've echoed back and forth a couple of times here about mediation. And someone mentioned before the Mediation Center of the Pacific. I'm wondering if that's something we should really consider and put it in the plan. Then it is fair, it's mediated, and it's part of the conference. And then both parties in the complaint process agree to mediation, period. I've seen how it works. It's fair, and both parties agree to it, and each party talks separately to the mediation, and they come up to a tentative agreement, and then they come together, brief chat, and then they settle it. When they do this in the court system, then it goes before the judge. The judge says, this is it, did you mediate, yes or no? Because if no, the judge is going to make a decision. Nobody wants to hear that. If it's mediated, it's fine. Everyone's friends. So I'm wondering if we should take that approach. My second comment is that my background is engineering, and we flowchart things. When I'm going through this process, I think, my gosh, should we flowchart it? I know it's going to take time, etc., but I'm not saying a flowchart the size of a football field. I'm saying something with key nodes to show, are we on the right path, or are we actually extending out the process beyond what it should be? Those are my comments. Thank you.
Thank you. One concern about putting in the Mediation Center of the Pacific, I think is what the term was. But what if they close? I mean, if they're have federal grants or something. So, you put that in the plan and then you're kind of stuck. I don't know, that's just a consideration. But
Well,
yeah.
we can actually augment it with our people. It's not just give it to them at all. I liked Larry's comments because you could use Mediation Center as their format and then they would chair that, so to speak. But we'd augment it with our commissioners. So we have the experts in the room, and we have a fair, biased, a recognized authority in mediation. And the way they handle things is different than how we do it. We do things based upon what we know. They do things more of a, not a global scale, but more, I don't know how to use the term. They use a different philosophy when they approach things. And what they do is good because it's good under the law. It's accepted by the court. So if we're going to try to simplify the process and expedite so we don't have, months of backlog of complaints, if you will, then that might be a good suggestion.
Okay, thank you. I guess something we can think about as we go into the next meeting.
Thank you.
Does anyone want to make any last comments? So we do have some things to think about and research for next meeting. I would say if anybody has any suggestions, they can submit it as testimony or they can send it to me. I'd be happy to bring up any suggestions. I would ask, make it kind of concrete. If you just say generalized platitudes, that's not really, I can certainly convey those, but that doesn't help us as much. But if you really want to have a good or a positive impact on the procedure, have some thought of how what you want to put into the plan, and be it take out from our proposal or improve it. So with that said, hearing no further business, we can move on to announcements. Are there any further business? Okay, so.
Kevin,
Kevin, please go ahead.
Chair, I apologize. You'd already moved to announcements, but I was just going to note that the file is sent. before the meeting did include some comments for sections H through L. If you can review them as you said you would, I'd appreciate that. And again, I'll be a strong advocate for the idea that if a respondent fails to reply in any fashion to a complaint, that is a tacit admission, and that the proceedings should adopt that as the processes go forward. Thank you.
Thank you. Well, unfortunately, we actually didn't adopt that. We talked about it pretty explicitly. I know we can revisit that, I guess, if the committee wants to, but unfortunately, yeah, we did pretty thoroughly review that, I think. So with that said, now we can move on to announcements. Our next meeting is scheduled for June 16th. Same place, same time, 6 o'clock. Either in person at Kapalama Holly. I'm sorry, I had to look that up, or online. And like I said, please send me whatever you have. You can submit it as testimony also. And if you submit it as testimony, we will put it in our folder, hopefully. And that's it. So with that, I'll call the meeting to an end. Thank you.